entire faith in our justice system, and they're making the right decisions.
That was the Prime Minister commenting on the news this afternoon that Paul Bernardo has been denied parole. The convicted rapist and killer lost his bid today at a hearing in Ontario.
It's been a very stressful day for the families. We're obviously relieved by the decision. We don't take anything for granted. It was a very difficult process for the families.
The National Parole Board says Bernardo is a dangerous offender and keeping him in prison does not contravene the Canadian Charter of Rights. Bernardo has spent more than 25 years behind bars for kidnapping, torturing, and killing 2 teenage girls in the early 1990s. The 54-year-old told the hearing today he did dreadful things in the past and that he cries over his crimes. The families of the murdered girls and one of Bernardo's rape victims urged the board to keep him in prison. So why do dangerous offenders serving life sentences have access to apply for parole? Joining me now, Mary Campbell is a former Director General of Criminal Justice with Public Safety. Hi, Ms. Campbell. Great to see you again. Thanks for coming back. Let's start with that very basic question. Why does someone like Paul Bernardo, convicted of the crimes he's been convicted of, the heinous crimes he's been convicted of, why is he eligible for this hearing?
You know, I think because fundamentally we have Canadian values, and those values in part say, no matter how remote it may seem, everyone is capable of redemption. Now, some people, that's a long road and they will never make it. But you have to bear in mind, Mr. Bernardo is a pretty extreme case. He's one of thousands of people that the Parole Board sees every year. And so Canada has made a choice right from the beginning, when our Parole Board was created in 1959, that everyone would be eligible for parole. But it certainly doesn't mean you're going to get it. Only about a third of the people who apply actually get parole. So there's this myth, I think, that once you reach 1/3 or 25 years that you get parole and you're out and life is great. And that's not actually the case. So why do we allow people like this to have a chance? The same reason in a way that we allow them to have a trial too in a courtroom. We're not Saudi Arabia, we're not Iraq or Iran. We do give people a chance.
What is the bar that has to be met in order to get parole? And I note a couple things that came out of the reporting today. For example, the stuff we talked about that he said during it, but that the lawyer for the victims' families afterwards said he did. For example, he didn't apologize. Do things like that matter in assessing whether or not parole is granted?
Well, you know, the parole hearing is what we call inquisitorial. It's not a trial. It's really an exploration of who this person is, what they've done, who they are now, and how they're likely to behave in the future. And really, if you had to boil it down to one word, it's about risk. That's really what the Parole Board is concerned about, is can we release you into society and manage any risk that you might pose? You don't have to be a saint, but your risk has to be manageable. So things like...
How do they determine that?
Well, in a variety of ways. There are what we call actuarial tests that have been validated that indicate, you know, roughly what your risk is, whether it's high, medium, or low. There will be psychology reports. There'll be reports from your case management team. An apology in and of itself is not particularly determinative. Sometimes an apology is an indicator that you do understand what you did and that it was wrong. But sometimes apologies are cheap as well. So
is remorse part of the calculation, the veracity of it?
Yes, and remorse really to the extent that it indicates that you really understand what you did. It's not just remorse saying you're sorry, because a lot of people can say they're sorry and there's not much depth to it. Parole Board would look at that, but they'd really look at other factors that are a bit more closely related to assessing risk.
The victims' families, some members of them were there today giving impact statements, and they told the Parole Board that the hearing forced their family to relive, this is Leslie Mahaffey's mother, to relive their daughter's pain and horror, and especially the idea that they had to be in the same room.
Right.
Is that necessary? Are there ways around it? Should it be something that the government or other bodies are looking at?
Short answer is no, and obviously the whole country grieves for the families and for the victims. The Parole Board has really gone out of its way to try to accommodate people, in terms of how they feel about it. And some people do want to be in the hearing room, no matter how painful it may be. But you don't have to be there. You could watch the hearing from another room. You could ignore it entirely and just listen to the audio tape later on. If you want to make a statement, again, you don't have to be in the room to make the statement. You can send in a letter, you can do an audio tape, a videotape, and that will all be presented at the hearing. So it is very much about a choice, and the board is quite sensitive to people who want to be there and others who just simply don't.